Record progress.
Assalamualaikum warahmatullahi wabarakatuh. This is Zoom recorded lecture for the topic damages, lecture 2. This is continuation of lecture 1. In lecture 1, first lecture, we covered until contemptuous damages. We were discussing about types or kinds of damages. So now we are going to continue with the second type or second kind of damages, which is nominal damages. So the word itself actually is self-explanatory. Nominal means something which is small. So what is nominal damages? So it is only allowed in torts that are actionable per se, actionable on itself. I mean, no need to prove damage whatsoever. So it is applicable, allowed in cases of injuria sine damno, which means there was an infringement of legal right, but there's no actual loss to the plaintiff. Meaning that here the right has been infringed, but there's no actual damage, which is suffered by the plaintiff. So in other words, a wrongful act by the defendant has been committed, but the plaintiff, as far as the plaintiff is concerned, he has not suffered actual damage or actual loss or injury. So because of that, the court only allows nominal damages. So plaintiff will receive a small sum of money in recognition to recognize the infringement of his legal right. So again, this is similar to contemptuous damages. It is considered as non-compensatory because of a very small amount. So it is not really to compensate as far as the objective or the aim is concerned. So we have the case of Constantine and Imperial Hotels. So let's have a look what happened in this case. Okay, this is very old case, 1944. So who was the plaintiff? The plaintiff, he was a famous West Indian cricketer. And he was trying to check into one of the hotels belonging to the defendant. So the defendant refused him to check in, to stay there. And plaintiff wanted to stay there. But still defendants provided him with lodging, accommodation elsewhere in some other hotels, not the one that the plaintiff wished to stay in. That's also issue of racism actually in this case. Okay, so the court held that yes, plaintiff was the right of the plaintiff was infringed because he was denied to stay in the hotel of his choice, but he was provided with accommodation hotel elsewhere. So the court held that so there's no actual damage suffered here. Okay, only damage to reputation. Okay, the plaintiff was annoyed with the defendant's action. So the plaintiff was entitled to nominal damages of 5 guineas. It's like 5 shillings. Okay, here, as he suffered unjustifiable humiliation and distress, but that's not actual damage because he got lodging elsewhere. So he got to stay in some other hotels. Okay, that's not actual damage. It will be different if he was denied accommodation at all. Okay, that will be actual damage. Okay, suffered by the plaintiff here. Okay, now we move to the third type of damages, which is exemplary damages. So exemplary, and in relation to the word example, okay, to serve as an example to others. So this is a unique, a unique kind or unique type of damages because it falls under punitive damages. Punitive means punish, something in relation to punishment. Okay. So what's the purpose of awarding exemplary damages here? Basically, the aim or the objective is to deter the defendant from repeating his act in the future. So I mean that here, example, or we want to teach quote unquote defendant of his own act. Teach something lesson to defendant here. And then most of the time, these exemplary damages, it is awarded together, in addition to general and special. So in one single case, there could be few categories of damages allowed, general and special, as well as exemplary damages like this, I mean, for this particular category or class of damages here. And then because it has the elements of punishment, punitive in nature, so the scope of application is limited, very limited, very narrow here. And another requirement, it has to be pleaded. I mean, plaintiff must ask for it. Okay, it's not for the court, the discretion of the court to award it. Okay, plaintiff must plead. Okay, must ask for it and must justify or must prove. Okay, why he should be entitled to this exemplary damages. So again, is it compensatory or is it non-compensatory? Is it something which is to compensate the losses suffered by the plaintiff here? That's a question or query here. Let's have a look at the case. This is the leading case, landmark case, which set the rule for exemplary damages, Rooks and Barnett, 1964. This is decision by House of Lords. In this case, Lord Devlin was the one who established the rule. So Lord Devlin, he said that exemplary damages are in principle objectionable, something which something which is to be objected. Okay, because why? Because this category of damages, it confuses civil and criminal functions of the law. Remember, what's the civil function? To compensate. Okay? Nothing to do with punishment. And criminal functions of the law is to punish. And therefore, they can now be awarded only in 3 exceptional situations, 3 exceptional circumstances. So it's very narrow. It's not applicable to all cases. Okay, let's have a look at the 3 exceptional situations here. Okay, the first one. Whenever the plaintiff has been victim of oppressive, arbitrary, or unconstitutional acts of the servants of government. Meaning that here the defendant is the servant of the government, and the act here in relation to oppression, okay, arbitrary or unconstitutional, against the constitution, basically. So we have the case of, do we follow this particular rule in Malaysia? This is common law, okay, taken from Rooks and Barnett just now. Yes, we do follow. We adopt the similar principle in the case of Fong Chi Chung and Inspector Muhammad Nasir, because in this case, the Malaysian court followed Rooks and Barnett, the rule which was laid out in by Lord Devlin in Rooks and Barnett. Okay, second exceptional situation, where the defendant's act has been calculated by him to bring him profit, okay, which exceeds the amount of compensation that he has to pay to the plaintiff. That here in the defendant's mind, whatever act that he was committing, still, okay, he will get more profit, even though he might be asked to pay the compensation later. We have the case of Sin Hibli, Marubani, Sin Berhad, and Yip Shao Shan. Okay. Usually it is relevant to the case of defamation, because defamation, it involves, most of the time, it involves huge amount of compensation. Okay, so in cases of defamation, I said just now, where the publisher, okay, had no genuine belief in the truth of what he published, and maybe in his mind he said, okay, I'm going to get a profit from this publication. So even if the publisher has to pay the compensation later, it will be more. I mean, the profit is more compared to amount of compensation. So in that particular situation, the court is justified, okay, to allow the pleading or the claim for exemplary damages on the part of the plaintiff. Okay. We also have the case of Castle and Company Limited and Broom. Okay, also to explain the second rule or the second exception situation. The third one, okay, straightforward, where a statute, okay, expressly authorizes the same. So we need to cross-refer to whatever statute which allows for exemplary damages. Okay, that's the discussion of exemplary damages. The next category of damages, the next type of damages is known as aggravated damages, from the word aggravate, okay, to make worse, to make it worse, to increase it more. So it is awarded when the plaintiff has suffered loss other than pecuniary loss. For example, injury to the feelings, okay, humiliation, for example, feeling of shame, loss of reputation, okay, and in awarding this category or this kind of damages, the court will take into account defendant's motive. Okay, what's the motive of defendant's act when the tort was committed? Actually, it's not really to punish as compared to punitive just now. Okay, as compared to exemplary damage just now. Okay, it's not to punish, but actually, the aim is to compensate. It serves to compensate for mental distress. Okay. So it's hard to calculate, okay, to what extent he suffered, the plaintiff suffered mental distress. And then again, okay, it is awarded in addition together, okay, to general and special damages, and it has to be pleaded. I mean, the court won't simply allow, okay, without the plaintiff asking for it. So it must be pleaded, and it is compensatory. I mean, it is meant to compensate mental distress, okay, mental feeling or humiliation or loss of reputation here. Okay, we have two cases to discuss about to show the application of aggravated damages here. The first case is Roshairi Abdul Wahab and Major Mustafa. It involved army, okay, who was being bullied here, okay, ragging. We have the word ragging. And then we have another case, Utusan Melayu and Janting Handicraft. It involved defamation. We are going to learn defamation later. So the question in these two cases, was exemplary damages awarded as well? Okay, in these two cases. Okay, let's have a look at the facts here. So in Roshairi Abdul Wahab, it involved a young officer, okay, who was a victim of ragging, okay, bullying lah, okay, bully. So he was kicked in ear. It's very extreme actually here. He was kicked in ear, okay, went on the ground, and then he was tortured. He was punched, but he survived. Okay, and it caused, okay, eventually it caused him deafness in the right ear, and mild deafness in the left. So almost become disabled, almost lost both of hearing. Okay, here. So the court held that although he was a young officer, although weaker and lower in rank compared to the one who practiced ragging on him, okay, but he, okay, the young officer here, he is still entitled to self-respect and dignity, okay, to treat as a human, okay, humanity. So the court allowed, actually, in this case, the claim for aggravated damages because of the nature of how it was done, okay, all the mental torture, and then also the injury that that was suffered by the plaintiff. Okay, compare this, but not compare. This is another case discussed about aggravated damages. The case of Janting Handicrafts and Berhad and Utusan Melayu, right? Utusan Melayu Berhad, reported in year 2001. This is appeal case. So who was the appellant? The appellant Utusan Melayu, okay, they were the publisher, okay, as well as editor, journalist, and printer. So here, four parties were being sued together, okay. And what was their publication? Okay, they published a monthly magazine called Wanita. Okay, those days we have many magazines, so this is one of the magazines, Wanita. Not sure whether it's still in existence today because of the online thingy, and then we don't have many hard copy, printed copy of magazine anymore. Okay, all right. So the first respondent, Janting Handicraft here, they carried on business of manufacturing batik materials. Okay, and the second respondent was its managing director and its alter ego lah. Okay, so the company also, the director was suing this Utusan Melayu. And respondent, okay, this batik company here, they were commissioned, okay, they get a contract by the Ministry of International Trade and Industry, MITI, to supply batik costume, okay, to all APEC leaders who attended the 1998 APEC meeting. So it was a highly reputable meeting lah, very famous, okay. And then respondent claimed that, okay, they were being defamed lah. Basically, this is a defamation case. They claimed that the appellants, Utusan Melayu, Bahasa Melayu article, okay, in Wanita magazine, had in their natural and ordinary meaning meant and were understood, okay, by the readers to mean that respondent produced unsightly batik, ugly actually here. And the second respondent had brought shame to the country. This is what being being written in the magazine, okay, as alleged by respondent, okay, shame to the country by allowing world leaders to wear unsightly and ugly costume, okay, the batik which was produced by respondent. That's what was being published, written and published, okay, by Utusan Melayu, by Wanita magazine. So now respondents were claiming for damages for slander of goods, okay, libel and aggravated damages. So did the court allow? Yes. Okay. See, usually defamation, it involves a huge amount of claim or money compensation. So the court at the lower court, okay, the court awarded. You can see the two citation there. Okay, first 201 and then appeal 205. So the court awarded the sum of 700,000 to the plaintiff as damages for libelous article. Okay, published in this is the general and special damages. Okay, and then the court also awarded 300,000, okay, as aggravated damages alone. They are being awarded together. Okay, for what? For considerable distress and embarrassment suffered by the plaintiff. Okay, because of the insulting and injuring words used by the defendants. But when the case went on appeal, okay, damages, I mean, liability was there for defamation, but then the court actually reassessed the damages. So damages were reduced to a total of 250 instead of total of 1 million here. So cut off by only quarter left, kan? 3/4. Okay, the last categories, usually this one, they go together. Okay, general and special damages. So we are done with the first 4, and then now 5 and 6. Okay, general and special. So general damages, and we need to compare with special damages. General damages, it is about unliquidated damages, whereas special, liquidated. Okay, what is meant by the word liquidated, unliquidated here? So unliquidated means exact amount cannot be quantified. It's not easy to assess. Okay, how much is the amount to be awarded? Compared with special damages, it is capable of pecuniary assessment. We can assess exactly. For example, 250. 250K. Okay, the exact figure or amount. Okay. And then for special, it's not presumed, but it has to be strictly proved. Prove it by way of whatever evidence, receipt, expenses, or whatever, okay, whatever document. But for general damages, usually the court will presume, okay, for this one, we award you 20,000 for your pain, for example. Because how do you prove pain? How can you prove it by receipt? Cannot, okay? So basically, general damages, it represents, okay, artificially the gravity of loss. Okay, if the gravity is very, very high, okay, if the pain is so tense, okay, so so extensive, extreme, then the court will be awarding higher amount. Okay, and most of the time, okay, general damages, usually it is the example is pain and suffering. Okay, we also have some other example, but for special damages, usually it refers to pecuniary loss. Plaintiff needs to claim for exact amount. For example, medical expenses, future medical, loss of wages, because we can tell exactly how much is the wage or salary, and as well as future loss of earning. We can calculate in the for a period of 10 years that plaintiff is supposed to work. So this is the amount that he has. He need to claim from the defendant who caused him the injury. Okay, the last case, for first part of our topic, damages. Someone Hong and Kadir Ibrahim Shah, 1981. This is appeal case. So the appellant was injured in a road accident. So what happened? As a result of which his right leg below the knee was amputated. So he lost the leg from the knee and below. Right leg, only one leg. So the finding by the court, observation here, the plaintiff was partly to be blamed to the extent of 25%. Meaning that here it's not 100% liability here. It's only 75% on the part of the defendant. So on 100% liability, he was awarded special damages. This amount 2,995 for out-of-pocket expenses. The actual expenses that he has paid from his pocket. So he can claim, right, by way of special damages. And the court also allows him 25,000 for actual loss of earning salary that he's supposed to get, but he lost it, due to the injury that he has suffered. And then when we talk about general damages here, he was ordered 35,000 for pain and suffering, because losing the leg here, right, knee and below, so it's really painful. So 35,000, the injury as well. And then loss of amenities, we have yet to learn. We are going to learn in the next part of the topic, personal injury. So he was awarded 12,000. So the 35,000 pain and suffering plus loss of amenities, and another 12,000 loss of earning capacity. We are going to learn what is meant by loss of earning capacity. But we total up, then we have to reduce 25%, because he contributed to the accident, I believe. And federal court approved the lower court judgment here, and then the federal court make it clear, distinguish between these two terms. Federal court explain, make it expressly stated that special damages consist of out-of-pocket expenses, such as, example, hospital bill. You can really prove it. cost of prosthesis, okay, artificial limb, facilities such as wheelchair, okay, cost of nursing care, loss of earning. Angel damages here, federal court said clearly, it comprises of damages for pain and suffering, loss of amenities, and the like, okay, which the law implies in certain cases includes future loss of earning and loss of earning capacity. So that's the difference between special and general damages. I think, okay, that's all for this particular, the second part, okay, for the second lecture, basically. Okay, today's recording of the lecture is meant to cover lecture number 2. Okay, that's all. If you have any question, you can ask the class. Assalamualaikum warahmatullahi wabarakatuh. I stop share. Okay, that's it.